This appeal is filed by the claimant seeking for higher compensation, being aggrieved by the judgment and award dated 14/6/2018, passed in MVC 6238 of 16 by the Motor Accidents Claims Tribunal, Court of Small Cases, Bengaluru. Though this appeal is listed for orders with the consent of learned counsel for the parties, it is taken up for final disposal. Srimati Nitya, learned counsel for Sir Prakash M.H., learned counsel appearing for the appellants, submits that the tribunal has committed a grave error in assessing the income of the deceased at 7,500 per month, as the deceased was a homemaker and also used to do tailoring work. Hence she used to earn more than 10,000 per month. It is submitted that the tribunal has committed a further error in deducting 50% towards the personal and living expenses of the deceased, whereas the appropriate deduction ought to have been one third. It is further submitted that the tribunal has not awarded the compensation under the head of loss of consortium to claimant number 2 on the ground that he is a major. Hence she seeks to allow the appeal by reassessing the compensation. Per contra, Shri Akshaya, learned counsel for Shri Ravi Shankar, learned counsel appearing for the contesting respondent insurance company, supports the impugned judgment and award of the tribunal and submits that the claimant have failed to substantiate the income of the deceased. The deceased was aged about 56 years at the time of accident. Considering the same, the tribunal has notionally assessed her income as rupees 7,500, which does not call for any interference. It is submitted that award of compensation by the tribunal is just and proper and does not call for any enhancement. Hence, he seeks to dismiss the appeal. I have heard the arguments of the learned counsel for the appellant, the learned counsel for the respondent, and meticulously preserved the material available on record. I have given an my anxious consideration to submit evidence on both sides. The point that arises from consideration in this appeal is whether the impugned judgment and award of the tribunal calls for any interference. It is not in dispute that the wife of the claimant number 1 and the matter of claimant number 2 died in the road accident dated 7/9/2016. It is also not in dispute that the vehicle involved in the accident was insured with the respondent number 1 and the liberty is also not disputed. It is to be noticed that at the time of accident the deceased was aged about 56 years and was working as a tailor. Considering the same, the tribunal assessed the income of the deceased at 7,500 per month. Though it is claimed that the deceased was going tailoring work, there is no material placed before the tribunal to substantiate the said claim. In the absence of acceptable evidence, this court please reliance on the national income chart prepared by the KSLSA and reassess the income of the deceased at 9,500 for the purpose of determination of compensation. The tribunal has deducted 50% of assessed income towards the personal and living expenses of the deceased. The said deduction runs contrary to the law laid down by the Honorable Supreme Court in the case of National Insurance Company versus Pranaya Shetty and others. Hence, the appropriate deduction should be on third as the claimants are husband and son of the deceased. In my consideration view, the tribunal has also committed an error in not awarding any compensation under the head of loss of consortium to claimant number 2. Claimant number 2, who is the son of the deceased, is entitled to a sum of 40,000 towards loss of consortium. Hence, the compensation towards loss of dependency is reassessed under. The tribunal has awarded a sum of 15,000 towards loss of estate and 15,000 towards funeral expenses, which does not call for interference. The claimant number 2 also entitled a sum of 40,000 towards loss of consortium. Thus, in all applicant shall be entitled to modify compensation under the following heads. Thus, the claimant shall be entitled to total compensation of rupees 8,63,2,400 as against 5,15,800 awarded by the tribunal. In the result, this court proceed to pass the following order. Appeal is allowed in part. The impugned judgment and order of the tribunal is modified to an extent that the claimant would be entitled to the total compensation of rupees 8,62,400 as against 5,15,800 awarded by the tribunal. The enhanced compensation amount shall carry interest at the rate of 6% per annum from the date of petition till the date of payment. The insurance company shall deposit the enhanced compensation amount with accrued interest before the tribunal within a period of 6 weeks from the date of receipt of a certified copy of this judgment. The apportionment, deposit, and disbursement shall be made as per award of the tribunal. Draw modified award accordingly.